Good afternoon, and welcome to Talk, the show dedicated to helping home health and hospice providers run compliant and successful agencies. Talk aims to bring you closer to reliable experts in home health and hospice and to share the latest news and information from the industry and from the Association of Home Care Coding and Compliance. I'm Jan Milliman, Director for and I'm happy to be hosting today's program. This afternoon, we're talking about recent developments with the Department of Labor's new independent contractor rule. And now I'd like to introduce our industry guests for this episode. We have AHC Board Secretary Robert Markette, JD, CHC, HCS-C, attorney with Hall, Render, Killian, Heath, and Lyman PC on the call today. Bob focuses his practice on representing home health, hospice, and private duty providers in all aspects of their operations. With more than 10 years of experience in working with these industries, Bob has developed a reputation for understanding the issues facing home care providers and has assisted clients in a number of areas related to the operation of their businesses. Thanks for joining us today, Bob.
Oh, thanks for having me, Jan.
It's always a pleasure. So today we wanted to kick things off with an audience poll. It's a quiz question today. So let me get that launched. And if you are listening live to this call, you can answer this question. True or false? Home health aid roles can generally be classified as independent contractors. And I see folks are voting, so I'm going to give it a couple of seconds to let folks get that in. All right, it's starting to pick up. Folks just needed to read through that. I think we're getting close to slowing down. All right, so it looks like folks have made their choices. So I'm going to go ahead and close out that poll, and then we will discuss the results a little bit later in the call. So let's go ahead and get the discussion or get the presentation started. Listeners, if you have any questions for Bob today, please go ahead and ask them in the chat pane, and we'll try to get to as many of those questions as we can. Bob, you have a lot to share with us today, so I'm going to turn things over to you, but just go ahead and let me know when I should advance to the next slide.
All right, well, we can probably skip this one. I don't know why I included it. I will, if you want to go back just one.
Oh, sure.
I do like to point out, whenever I do a presentation like this, two things. One, we're talking about a legal subject, and I'm a lawyer, but nothing I say today is legal advice. The purpose of this presentation is educational. Even if you ask a question, I answer it, it's not legal advice. And I don't say that to force you to have to call a lawyer when you have, and pay them by the hour to answer the question, but as you'll see today, this is a very fact-specific issue, this question of employee classification, or worker classification, I should say. And the facts do make a difference. And so my goal today is to kind of give you the lay of the land, so you know where the red flags are. So when you're thinking of an employee, or again, worker classification, employee is a classification. I keep slipping. If I say employee classification, I assume the answer, right? So worker classification, when you're looking at these issues and something comes up where you think you might have an independent contractor, you might have some questions about this particular individual's classification, you know, okay, these are risks, and you know to seek out advice so that you don't get yourself crossed as a DOL, because this is an area of DOL focus. And secondly, everything I say today are my opinions. They are not the opinions of AHC, Decision Health, or Hall Render. I say that because if you've heard me speak before, sometimes I offer my own personal opinions about some of these things, and so keep that in mind. And finally, remember, I'm the messenger. I've spent my entire career representing home care, and I know whenever I talk about worker classification and certain other employment and labor issues, some of the conclusions are counterintuitive and can be somewhat frustrating to owners and operators and HR folks. I get that. I'm on your side. I defend home care companies from the DOL and DOL investigations. I'm just the messenger. I don't necessarily like the rules either, but these are the rules, and I'm just here to tell you about them. So that, we can go on to the next slide.
All right.
So worker classification. This is an important issue under both the Federal Standards Act, which is the federal law, which governs your relationship with your employees in terms of their wages, hours, and overtime. It also is an issue under other federal laws, the most important one being the Internal Revenue Code. As an employer, you have to deal with withholding of certain payroll tax, et cetera, for your employees. And misclassification of workers has been an issue for both the DOL and the IRS for many years. The DOL is concerned that there are workers out there who are not receiving the wages they ought to be receiving because they've been misclassified as independent contractors. The IRS is concerned they're not getting all the taxes they should be getting, especially the Social Security and Medicare taxes, because employees have been misclassified. And as you've been paying attention, the federal government is a little short on cash right now, so they're looking to generate all the revenue they can. So this has been an issue where they've both been focused on, and they've been sharing information to make sure they identify workers, or actually employers who have misclassified workers, and they will work together to recover in some cases. And we are aware of cases where the DOL has shared information with the IRS about misclassification. It's very important to get this right, because if you get it wrong, you could be looking at issues of DOL, back wages, liquidated damages, which is they take the wages you didn't pay, so in general, in these cases, overtime, and then double that. And in recent years, the DOL has taken the position that liquidated damages is appropriate for a first-time offender. It used to be that if the DOL came out, you'd get investigated. If you were mistaken, they would work with you to get in compliance. You'd pay the back wages with interest, and that was generally the end of it. The last couple of years, we've seen a real uptick in demands for liquidated damages, which doubles the bill and can make things very expensive. And then obviously the IRS, if they show up, there can be significant penalties for non-payment of Medicare tax and failure to properly withhold taxes. And in both cases, especially for smaller, closely held companies, owners can be at risk for the amounts owed both to the DOL and to the IRS. And we've seen a lot, especially on the DOL side in the last 2 years, of focus on home care. The DOL has an entire page at its website dedicated to home care employers, and we've been listed at healthcare generally, but home care specifically, as a high risk, high non-compliance sector. So you'll see, if you go to the DOL's website and look at their press releases, you'll see a lot of cases involving home care providers around the country. You'll see a lot of cases involving misclassification. They've gone in and investigated. I'm currently handling 2 of those in Indiana right now, and I'm talking with DOL in our region. I'm aware of several other of these investigations that are going on currently. So this one you really want to get right, because they're focused on it. And the more, as we've learned in other aspects of home care compliance, the more resources the government puts into enforcement, the more likely it is your mistakes will be identified. So go on the next slide, Jan. So the big news here is this year, DOL published its final rule on worker classification. They call it the Employer Independent Contractor Classification of the Fair Labor Standards Act rule, or more shortly, the Independent Contractor Rule. This rule has been in the works for a while. There was a proposed rule last summer, and this comes out of the current DOL's desire to undo the Independent Contractor Rule the Trump administration promulgated shortly before they left the DOL at the end of the Trump administration. That rule got published. The DOL, under the new leadership, very quickly tried to repeal it. Litigation ensued, and the courts ruled that the current DOL failed to properly follow the Administrative Orders and Procedures Act in repealing the rule or rescinding the rule, and thus the rule stayed in effect, which led us to this rule that was finally published on January 10th and has now taken effect. And this is now the regulation that governs employee, or say worker classification under the Fair Labor Standards Act. Go ahead to the next slide, Jan. So this final rule adopts the economic realities test. Now, the economic realities test was the same test that the Trump era rule adopted. It's the test you'll see the courts discuss. In fact, economic realities has been the term of art for this, for how you assess a worker and whether that worker is an employee or an independent contractor, going back to the 40s. So this concept of economic realities is pretty well established. The regulation sets forth these factors. So when you're looking, or so when the DOL is looking at a worker to assess whether an employer or an independent contractor, they're going to ask, is there an opportunity for profit or loss depending upon managerial skill? Who makes the investments in equipment, supplies, etc.? What is the degree of permanence of the working relationship? What is the nature and degree of control the alleged employer has over the work of the alleged employee? What is the extent to which the work done by this worker is an integral part of the alleged employer's business? Is it part of it, or is it extraneous to? What kind of skill and initiative is involved? And then additional factors. The regulation specifically allows the DOL to consider additional factors when evaluating whether or not a worker is an employee or an independent contractor. And that gives them some room to maneuver, because you can imagine if I'm the DOL or a plaintiff's attorney, I can think about a number of things that weigh in the favor of the direction I want to go, and it will work for the employer as well. So the rule is a little different than the Trump era rule. The Trump era rule cited the first two factors. I'm sorry, the Trump rule cited opportunity for profit or loss and control as the core factors, and you can generally eliminate or end the discussion at those 2 points, depending on how they came out. That was done for simplicity. They're trying, the DOL and the Trump administration is attempting to, they said, simplify the analysis to make it easier for employers. This does not have core requirements. The DOL is very clear. All of these factors and others can be considered. They all apply equally, and it's the totality of the circumstances that determines whether or not a worker is an employee or an independent contractor. All right, you go to the next slide, please. It's important to note that with the exception of the core factors, noting the 2 factors as core factors, I should say, this regulation is very similar to the Trump era regulation, and it's very similar to federal case law that has developed since the 40s in terms of the factors the courts have looked at in assessing whether or not a worker is an employee or an independent contractor. And it's interesting because you find out a lot about this rule, and then it's going to really change the analysis, and it's really going to alter who is or is not an employee. And that may be the case in some areas. I think the bigger factor is that this current DOL takes a very expansive view of who is or is not an employee, more so than the rule, because the rule, like I said, follows the same basic factors that the courts have followed for many years. And the DOL specifically notes in the comments to the rule that they were concerned that the Trump era rule did not fully comport with the established case law and the text and purpose of the rule. And that what they had done with establishing core factors was to depart from decades of case law that applied the economic realities test. I think that's an important quote here because it puts the Department of Labor in the position of having defended the need for this new rule. Because keep in mind, the DOL had just published a rule on this factor, and here we are just a few years later with a whole new rule, and they're aware that there was a risk of this being litigated, and so they're trying to make the case as to why was it necessary to change the rule so quickly. And they built their argument around the old rule departed from the established case law. And I think that helps us in some sense, because that means if the DOL applies the rule, they can't get too far afield because they anchored themselves to the decades of case law. And that is the economic realities test as established by the courts. You can go to the next slide, Jan. So this is just an example. I've had this particular slide, and I've used this in a number of presentations over the years. This is one court case. Let's go back to '87, but I could pull up a dozen cases or more, like from the 40s, the 50s, even in the 90s and 2000s. When the federal courts look at whether or not an employee, I should say a worker, is an employee or an independent contractor, and this comes up in a fair amount of litigation over the years. It came up a lot more near the beginning when employers were attempting to come to terms with the Fair Labor Standards Act, but it's still an issue that comes up with some frequency. And the courts, what do they look at? Nature and degree of the alleged employer's control, workers' opportunity for profit or loss, workers' investment in equipment or materials, whether the service rendered requires a special skill, the degree of permanence and duration relationship, and the extent to which the service is an integral part of the alleged employer's business. So that's a case from 1987, and we're now in 2024, and we see the factors are very similar. So we have some consistency, and then I think we're going to rely upon, there may not be a huge sea change here in terms of the rule. It's really going to be the DOL's interpretation, application of the rule to what we're doing. You go ahead to the next slide, Jan. So I already told us a little bit that the 2020 rule focused on those two factors as core factors, but the current rule, the new rule, focuses on the totality of the circumstance, and that's what the courts tended to look at. And the courts will consider other factors. The 6 factors that are outlined in the court case I demonstrated, you'll see courts look at other factors as well, but those 6 tend to be the ones they look at the most. But you will see the courts talk about the totality of the circumstances. They look at the totality of the relationship. And the courts don't necessarily consider one factor more important than others, but again, depending on the situation, the number of factors that are involved, obviously it can change the weighting. And I have noted that there are a lot of concerns. You've probably seen a lot of reporting that this is going to really change things. Everyone's going to be an employee now. And really, I think the focus here of concern is for folks in the gig economy. There's some sense that the DOL is trying to expand its reach because it believes that certain gig economy workers should be employees, not independent contractors. That, as we'll talk about, I don't think has as much impact on us in home care, but I do believe from conversations with DOL investigators I've been working with of late, this current DOL does apply this regulation and this concept much more broadly than the Trump era did. And that's not surprising. If you've been in home care long enough, and I've been doing this now for a lot longer than I realize sometimes, but I've had the opportunity I started during the Bush administration, the Republican administration, then the Obama administration, then the Trump administration, then Biden. And one thing you'll see, and you've noticed as well, as administrations change, especially when they change from Republican to Democrat or back, you will see differences in interpretations, differences in application. We see that with CMS and others. And this is another example. This, well, as tends to happen when you have a Democrat administration, takes a much broader view of who is an employee, a much narrower view of who is an independent contractor. And we're seeing that play out in their investigations. And that, I think, has a larger impact on how this rule applies than anything else. You go to the next slide, Jan. Again, as I know, the comments does limit them somewhat. They've thoroughly tied themselves to the history of the economic realities test, going back to the very, very early era in the Federal Standards Act. But eliminating the core factors and focusing on the totality of the circumstances gives them more room to interpret. And this is where the real focus is on, I think, the starting assumptions of the administration that all workers are employees, because they can emphasize the totality of the circumstances, which circumstance is more pro, this is an employee, not an independent contractor. And since all the factors can be looked at equally, and they can consider additional factors, it allows them to really dig and to push to get to, look, this is an employee, this is an employee. And they'll do that through their interpretation, through how they see the weight, how they argue for which factors are more important than others. And again, it's a totality, but they'll focus on those factors that help their case more. And go ahead to the next slide, Jan. So the other thing to keep in mind here, and I've already told the first bullet point, but they're going to apply the factors from their starting assumption. You know, the old adage, if I have a hammer, everything looks like a nail. Well, if I think everything's an employee, then this test is going to find everyone is an employee. And so you have to remember the burden is on you as the employer to demonstrate that the worker is an independent contractor. They're going to start from the assumption. And I've seen, we've had some big cases of late involving workers who are family members who are paid through a state Medicaid waiver program to provide care, so parents caring for their children, which doesn't look like a traditional employee, because it's the state's paying me to basically pay these folks to provide the care they're providing already. It's not like I created a company or a job for them. My company is new, but their job, they're getting paid to what they're doing anyways. doesn't look like a traditional employee, like say I hire you to come in and work at my factory, but the DOL's assumption is that they are employees, and the burden then becomes the employer to point out, well, why is this person that you're paying not an employee? So you have to think about that when you're classifying your employees, that you'll have to defend the position, and if the DOL disagrees with you, it can get very expensive. Next slide. Now here's the one thing I think for us. If you look at the factors, I do think there are some industries where the change in rule will give the DOL room to expand who's employed. But for home care, I think we come to the same conclusion under the case law, the Trump era rule, and this rule, that our workers, with very limited exceptions, are employees, not independent contractors. Because you're going to look at the factors and then your relationship with these employees to determine, what they are. So when you look at control is a big one. We are, as home care providers, generally operating a license, operating Medicare rules, Medicaid rules, have to have a plan of care, have a schedule. We are expected by both Medicare and the surveyors to make sure that schedule is fulfilled. We have doctor's orders that order certain amounts of care. If we miss a visit, we have to know about that so we can inform the doctor and go through our missed visit practice. So we have a significant amount of control because we're providing care to the patient. We expect them to fill out documentation a certain way and to document in certain forms or EMR and to document autonomy. So we have a lot of control. There's no opportunity for profit or loss. Opportunity for profit or loss means if I'm more efficient, I make more money. So I bid a project. I tell you, I can complete this project, say building out your IT system for $1 million. If I'm efficient, I might make $100,000 extra because of the time I saved and got done faster, so I reduced my labor costs. Our workers, our nurses, our home health aides, et cetera, they can make more money if they work more, right? That's one reason so many folks are fond of per visit pay. The more you work, the more you make. That's not increasing your profit margins by being more efficient. That's simply working more hours. Investment in equipment and supplies. Generally, we as the employer provide the point of care device. We provide the medical supplies and all those things. We may provide a car. We may provide reimbursement for the use of their car. They might provide their scrubs, but the bigger expensive items we pay for. Degree of permanence. There's been a number of studies lately about the cost of hiring new employees in the current marketplace, and we would prefer that relationship to be permanent. We want to keep them because of the investment. So all these factors keep coming down the side of their employees, and it's been that way for a very long time. So you need to keep that in mind. It's not what you call them. I've had employers, I'll sign this contract with you, an independent contractor. That doesn't matter. I can call you an independent contractor. I have you sign an employment agreement that says, it says independent contractor agreement. But the DOL and the courts look at those factors and the relationship itself in light of those tests. Go ahead and go to the next slide. So I've already touched on the first 2 points, but the last point, it's the test. How the test applies that determines the outcome, not your description of the relationship, not your title of the employee, not the agreement the employee signed. You know the next slide, Jan. So if you're going to classify them as independent contractors, you need to be careful. If you think you identified a worker who's an independent contractor in home care, I recommend seeking legal advice. Get a written opinion letter from an attorney that tells you that they're independent contractor. The reason I say that is because if you have that written opinion letter, you can then make the argument that you've got a good faith reliance on the advice of counsel. The DOL may disagree with you, and ultimately a court may conclude that the attorney's opinion is wrong. But this comes into play in a couple of places. One, was your violation of Fair Labor Standards Act willful? If you had a willful violation, the statute of limitations period goes from 2 years to 3. So instead of looking at 2 years of back wages, you'll be paying 3. And also, again, this doesn't apply as much as it used to, but traditionally, if I had a good faith basis for what I did, I would avoid liquidated damages. I still think you have that argument. There are other factors you get to court as to whether or not a court would impose liquidated damages, but I think it's very important. If you went to an attorney and you sought advice of counsel and you relied upon that advice, that's a very strong argument in good faith. Now, there can be other factors, like I said, but so it's highly recommended because the DOL is going to make the opposite assumption. You go to the next slide, Jan. Oh, well, we're at the end. So the big conclusion here before I hand it back to Jan is just that the DOL's presumption is these workers are employees. You need to think about that. Think about this, that it's this economic test that applies. it's the totality, no one factor controls, and the current DOL is looking at us because one, they think home care does not pay its employees enough, we don't treat them correctly, and two, that we're misclassifying folks. And so if you have independent contractors, you need to go back and look at them and ask yourself, when I look at this test, are these really independent contractors or are they employees? Because the odds, in my opinion, are very strong that they're employees, not independent contractors. And I know even if they are, the DOL's position is likely going to be for employees, because that is what I have run into in dealing with the DOL, is they see all workers as employees. So that I will throw it back to Jan.
Thanks so much, Bob. That had a lot of great info. Let's take a look at our poll and see how folks were thinking about this as we went into the presentation. So our question was, true or false, home health aide roles can generally be classified as independent contractors. And most of our folks did say that was false, but we did have a few people who thought that it was true. Bob, any thoughts on that?
I'm actually pleased with the results. One of the most common misconceptions in home care, when I deal with, I do presentations around the country on top home care employment mistakes, and one of the common mistakes is misclassification, often because of what I call urban legends. And so 86%, that's really, and the folks who got it wrong, they're not alone. Lots of people make that mistake, and not just in home care. So, I don't feel bad if they got the answer wrong, but it's heartening to see that 86% got it right.
Yeah, that's great. Wonderful. All right. So now it's time for us to move on to what's new with AHC. And I just want to encourage folks who are a Board of Medical Specialty Coding certification holders to take our annual survey. It's now live, and the link is there in the handouts if you're listening live. We want to know what your certification means to you and how we can better serve you. So please follow that link and let us know what your thoughts are in this year's survey. And if you haven't downloaded the handouts as part of the live call, you can find them on the AHC website at ahcc.decisionhealth.com under resources and then free webinars, and those will be posted soon after the live call. We also wanted to mention that if you're interested in learning more about running a successful and compliant home health agency, Decision House Home Care Administrators Field Guide is a great resource. This guide includes a strategic breakdown of the organizational structure of a home health agency and explores and explains the administrator's role in operations, human resources, financial management, OASIS payment, public reporting, and regulatory compliance. And this month you can get 15% off the guide at the Decision Health store with the coupon admin15.
I can just say, Jana, that is really good manual. I don't say that just because I wrote it.
Thanks, Bob. Agreed. We hear from so many people how important it is to their work. So good to have you involved with that product, and hope folks will take a look at that. We hope you enjoyed this episode of AHC Talk. Thanks so much, Bob, for all the great information. And thanks to our listeners for tuning in. Sorry, Bob, were you going to?
I was just say, thanks for having me, and thanks everyone for taking some time out of a Monday afternoon to listen.
Yes, agreed. We hope you will all join us again for our next call, which is April 15th. And members of the AHC board will be discussing technical reasons for recent hospice claim denials. And in the meantime, if you'd like to listen to this episode or a previous one on the go, you can now find AHC Talk on your favorite podcast app. And if you have any suggestions for future guests, topics, or ideas about the format of the show, please send me an email at jan.milliman@decisionhealth.com. Thanks so much for listening, and we'll see you all next month. Take care.